ladies and gentlemen, Joy Stephen from the Polensis Studios. Here is another case law for the Student Herald. Ismail versus Canada. Case law is not meant for people interested to apply for immigration to Canada, but may be used by those who feel the system is not fair or to gain an understanding of the recourse available in Canada for a negative decision. Content for this video is sourced from information distributed by Thomson Reuters. Judgment for this case is attached as a PDF document in my blog, reportersreport.com. This case law is about immigration, exclusion and expulsion, removal orders. The principal applicant was citizen of Egypt who applied to come to Canada under a skilled workers program. She submitted language testing certificate IELTS and was granted permanent resident visa, along with her co-applicants, her husband and a daughter. When applicants arrived at the airport in Toronto, they presented their permanent resident visas and were examined by an immigration officer. When principal applicant was not able to answer simple questions in English, officer checked computer database and noticed that visa officer in Cairo had determined that IELTS results submitted were fraudulent. Visas was nonetheless issued, likely because of civil unrest in Egypt at time, which resulted in interruptions in processing. Applicants were permitted to enter Canada under S23 of Immigration and Refugee Protection Act for purposes of attending examination at a later date. On November 23rd, 2011, visa officer revoked applicants' permanent resident visas. Applicants then attended examination on December 2nd, 2011. The exclusion orders were issued against all three, given that they did not have valid visas. Immigration Appeals Division IAD dismissed applicants' appeal of decision. IAD found that applicants had not shown on basis of information provided that they had right of appeal in circumstances. Applicants applied for judicial review and decision of IAD application was dismissed. There was no doubt that visa could be revoked at any time after having been issued. It was clear from textual, contextual and purposive analysis of S63(2) and Act as whole that right of appeal was granted only to person who held valid permanent resident visa at time exclusion report was issued. Foreign nationals who were found to be inadmissible at port of entry or at deferred examination would have right of appeal to IAD only when their inadmissibility did not relate to absence of permanent resident visa. Interesting case, Ismail versus Canada, March 17th of 2015. Adios.